of everybody's time, we can go ahead and just do introductions.
Yeah,
Desmond, if you want to introduce yourself, and then Dustin and Dan and I can each introduce ourselves, and then we can get into the substance, and hopefully by that time some other folks will have jumped on.
yeah, that's a great idea. So I'm Desmond. I'm the president of the Student National Cannabis Bar Association. I'm a 2L, and I'm just very excited to have this panel today about Florigrown.
Awesome. Dustin?
My name is Dustin Robinson. I'm the founding partner of Mr. Cannabis Law, which is a law firm exclusively focused on the cannabis space. I'm also the founder of Mr. Psychedelic Law, which is a not-for-profit focused on legal reform in Florida of psilocybin mushrooms and other entheogens. And I'm a triple gator, so I'm super pumped that the UF Law team is taking a leading role in this cannabis industry.
Dan?
Good afternoon. My name's Dan Russell. I started in this industry back in 2014 as the first outside general counsel for Tara. And since that time, I've represented a number of companies, a couple of whom I work with Tara on professionally. We share clients with. So we have been excited to work together and looking forward to this opportunity. And thank you to the university. I'm not a triple gator, but I am at least a single gator. So I got that going for me.
And I am a single gator as well, a UF alum for law school. I'm Tara Tedrow. I'm a shareholder at Lowndes Law out of Orlando. I chair our firm's Cannabis and Controlled Substances Practice Group. I'm an adjunct professor at the University of Florida. I've taught marijuana law and policy there for 3 years. And I chair the state's hemp advisory board and I'm also appointed by the Florida Department of Agriculture and Consumer Services to the statutorily created hemp advisory board. So my practice focuses on land development, marijuana, as well as hemp. So excited to be here today. Desmond, thanks so much for having us. I know we were going to kick it off with the state of cannabis regulations. Is that right? Because I was going to give a brief overview of that.
Yeah, if you want to just go right into that.
Absolutely. Well, we'll say first and foremost, for those who might be watching this because we are recording it, you didn't get in on our Zoom link that we had posted. Apologies for that, but thank you very much for joining us live or watching this after the fact. So when it comes to medical marijuana in the state of Florida, our regulations have dated back to 2014 when the Compassionate Medical Use Act was enacted. And that allowed for low THC, high CBD products to be provided to eligible patients in the state of Florida. The very limited class of eligible patients for chronic muscle spasms, seizures, and cancer. And again, it was only that low THC product that could be obtained after having a valid recommendation from a licensed physician that you had to see for 90 days to be able to get that recommendation. After that point in 2015, the Right to Try Act came out, which allowed for high THC products for those patients who were terminally ill. So essentially an experimental drug for end-of-life patients. I think when everybody realized the sky wasn't falling because medical cannabis was permitted in 2016, Amendment 2 passed by an overwhelming majority of voters here in the state of Florida. And so that constitutional ballot initiative is what greatly expanded the industry, especially those qualifying conditions, and allowed access for both low and high THC and CBD products here in the state. Then in 2017, under Senate Bill 8A, we had additional regulations that came about that were implementing that constitutional ballot, which, by the way, that's the language that we're going to be talking about today, and some of those distinctions between what was in the original constitutional ballot language versus what we had in Florida statutes under 381986. If you have looked at the statistics on the industry, those are put out every week by the Department of Health, Office of Medical Marijuana Use, which is primarily governing the industry here in Florida. The Florida Department of Agriculture and Consumer Services does have some limited authority over medical cannabis, particularly when it comes to edibles production, which we now finally have rules for edibles in the state of Florida from both the Department of Health and from FDACS. But as of last Friday, there were 427,181 patients here in the state of Florida, 282 dispensing organizations, over 124 million milligrams of marijuana products that were dispensed during last week, over 3.4 million milligrams of low THC cannabis products dispensed to patients, as well as 48,000 ounces for smokable products dispensed as well. So a significant amount of cannabis being dispensed to those eligible and qualified patients here in the state of Florida on a weekly basis. And you can see, again, if you like dorky statistics of the cannabis industry, every Friday you can just see kind of the upward trajectory that has happened in that industry since COVID, but really also since the inception of it as well in 2014. There are 22 licensed medical marijuana treatment centers in the state of Florida, and a lot of folks have taken umbrage with the fact that there is such a limited number of licenses, and so that's something else that we're going to talk about today. And so that is sort of the overarching state of the cannabis industry in Florida. I promise if you took my class, I would tell you a lot more information than that, but I think that at least gives a good primer as to where we stand with what is a required vertically integrated market. So all of our 22 licensed companies grow, process, and dispense via at-home patient delivery or brick and mortar retail dispensing locations, products to patients statewide. So with that, I will turn it back over to you, Desmond.
Thank you. And Dan, could you set us up for the Florigrown case and tell us just the background overview? What is it and how did it get before the Florida Supreme Court?
Sure. So I'll take us from circuit court filing up through the first round of the DCA and then the attempt for an en banc hearing. So by way of background, several years ago, Florigrown, which is a seed company in the hemp and cannabis space, filed a piece of litigation challenging the constitutionality of the implementing statute that followed Amendment 2. And so backing up even further, Amendment 2 passed, as we all know, by about 72%. We couldn't get 72% of Floridians to agree on anything, in my opinion, except medical marijuana. So we were able to do that, which was great. What followed was implementing legislation by the Florida legislature that brought granularity to an amendment which is required by law and by constitutional requirements to be rather short. And so it is additional guidance brought by the legislature to allow the Department of Health to implement Amendment 2. That's the crux of this litigation, was a challenge to the constitutionality of the vertical integration requirement, among other things. The vertical integration requirement that most of us probably know, but I'll go ahead and just sort of give you the background on that as well. Vertical integration requires each of the 22 MMTCs to cultivate, process, and sell all of its own products. If you walk into a Trulieve, you'll only find products that were grown, processed, and then obviously sold by Trulieve. Same for all of the other locations in the state of Florida. So Florigrown challenged not only the vertical integration requirement, because Florigrown wants to be a cultivation company, they also challenged as a special act some of the statutes that authorized almost immediate licensure for additional MMTCs, folks who had active litigation and whatnot. So it started at the circuit court in Leon County in the Second Circuit, and the ultimate order from the circuit judge was that there was a temporary injunction going to be put in place against the Department of Health, awarding Florigrown an initial victory at the circuit court, which was obviously appealed by the Department of Health. So up at the first DCA, there was obviously some intense litigation and oral argument in that case. And effectively, on the issue of vertical integration, there's a definition in Amendment 2 of what an MMTC is. It is definitional, and I'll read it into the record just so everyone can understand this crux of it. So an MMTC is defined by the Constitution as an entity that acquires, cultivates, possesses, processes, transfers, transports, sells, distributes, dispenses, or administers marijuana products containing marijuana, related supplies, or educational materials, etc. The "or" there, two-letter word, is the entire crux of that issue. Argument from the department would be, this is just a definition to say to the people of the state of Florida what an MMTC is. The argument from Florigrown is that that "or" is critical because an MMTC can do any one of those things, but does not have to do all of those things. So that's your pinch point there. If we talk about textualism or originalism, what are the words there? Well, or is an important word, and there's no black and white answer, in my opinion, on what that means. If this was in a substantive section, I think we'd have a much clearer argument. However, we'll get to that later. It's already still at the Supreme Court. So the first DCA ruled and then had to rule again against itself. So let's go back. We get a ruling out of the first DCA and then move for an en banc hearing. And what an en banc hearing, for those of you who aren't litigators or litigators yet, is effectively asking for a rehearing of an appellate court's ruling, but rather than just of a traditional 3-judge panel, because once you're at the District Court of Appeals, for the law students who may not have gotten here yet, when you're at the DCA, you're not just presenting to one judge and you're not presenting to a jury. Your panel is 3 District Court of Appeals judges. When you go en banc, it is a hearing of all of the judges on the first DCA. Interestingly, there was a tie, so there was no en banc hearing. They voted on whether they're going to go en banc, and 5 judges recused themselves entirely. So you're left with a tie. So there was no en banc hearing. There was a ruling not to go en banc that then went to the Supreme Court, which is a very interesting way to get there. It's rather rare. So now we've sort of backing up all the way. Florigrown wants to get a license, in my opinion. I'm not their counsel, but the way I've read their pleadings. Florigrown wants a license, but does not want to get an MMTC license as it's defined in statute today. They would like an MMTC license highlighting the "or" in the constitutional language that would allow them to cultivate or process or retail. And Florigrown being a seed company, I would assume they'd want to be in the cultivation business. So that brings us from the trial court all the way up to the Supreme Court, where you have the original hearing. And I'll bump it back so I don't take up everyone's time, so that you can have a little discussion about what's going on at the Supremes. And I definitely want to get into it with my other 2 panelists on what's going to happen, how did we get here, those types of arguments. But I'll kick it back to you to dole that out.
Thanks, Dan. So Dustin, could you tell us what the importance of the outcome of the case would be for the cannabis industry in Florida?
Yeah, so I'm going to kind of pick up where Daniel left off, but I'm really going to talk mainly about what are the implications of the Florigrown case, because that's essentially what most people want to know. You know, what are the possibilities? What's going to happen? What are our predictions? The first thing to understand is that it's very, very hard to predict how the Supreme Court is going to rule in this case. I've talked to Tara, Daniel, a lot of other attorneys, and everyone has a different take on where this could potentially come out. But the one thing everyone kind of agrees on is that they're not quite sure. So first thing to understand is we really don't know the way the court is going to rule. So I'm going to briefly discuss some of the possibilities, but I'm going to leave plenty of time for you guys to kind of ask some questions. The 3 main ways that the court could rule, there's 3 things, and really there's thousands, but I'm going to oversimplify it. Either they're going to find in favor of the DOH on all the issues, they're going to find in favor of Florigrown on all the issues, or they're going to do something where they find in favor of DOH on some of the issues and in favor of Florigrown on some of the issues. Obviously, that's a more simplified kind of summary of how they could rule. But let's first talk about what would happen if they found in favor of the DOH. So essentially, that would mean that the vertically integrated structure and the caps are not unconstitutional, and that the statute is not an unconstitutional special law. So if they actually were to find in favor of the DOH on the merits, then this would mean that there's no longer this temporary injunction on the DOH, and the DOH may start issuing additional licenses. According to DOH, if you watch the oral hearings, there are 11 licenses available under Florida Statute 381.986 subsection 8. So the DOH would basically open up that application process. Applicants would submit their applications. There'd be the scoring of those applications. Then they would award licenses. Now that is likely not the end of it, because what could happen after they award licenses is that there may be a flurry of lawsuits. And we're seeing this in Illinois. Illinois just announced their lottery picks for retail licenses, and very quickly a lot of the applicants that didn't make it into that lottery basically sued the state, and then the lottery people sued the state, and right now Illinois doesn't really know what they're gonna do, and I don't think that's gonna get resolved for several months. So it's important to understand that even if they find in favor of the DOH and the DOH quickly moves forward with an application process, there's still the possibility of some additional lawsuits once those are awarded. And my prediction is that there's probably going to be potentially up to 10,000 applicants that are applying for these 11 licenses. So what that means is it's going to be extremely competitive, but it also means people are going to be spending significant money on these applications. And if they don't win, the only thing you could really do is potentially sue. So it's just something to kind of keep in mind, that even if the court finds in favor of the DOH, and even if the DOH tries to move quickly with the application process, I don't think we'll see operational licenses until probably early 2022. So that's just a reality. I know people don't like to hear that, but the reality is the whole process takes very long, and there's just kind of obstacles at every part of that process. So the next situation, let's assume that the court finds in favor of Florigrown on all the issues. So that would mean that the statute is unconstitutional, whether it be considered a special law or whether it be just unconstitutional because the vertical integration is unconstitutional. Depending on which pieces of those the court finds, we could have different rulings from the court. But what's important to understand is that there's a severance provision in Florida Statute 3 at 1.986. So that severance provision allows for certain provisions to be severed from the statute in the instance that it were found to be unconstitutional. So it's possible that those provisions could be severed, and the DOH could directly create this horizontal structure without the legislator going back and doing anything with the statute. Now, I think that is extremely unlikely. We have a legislator that wants to be extremely involved in the structure of this cannabis industry. So the more likely thing that will happen, in my opinion, is that if this were deemed unconstitutional, is the legislator would go back in this next legislative session and probably, well, it depends on when this ruling comes out, but hopefully it comes out soon, and we'll see the legislator in this next legislative session passing some sort of statutory structure that's horizontal. What that might look like, we don't know. We really don't know, and anyone who tries to claim that they know what it'll look like, they don't know what they're talking about. So it could be that they break up all parts of the supply chain. So they could break up for everything from cultivating to processing, dispensing, delivery. All those would be separate licenses. They could couple up parts of that supply chain. So they might have licenses that allow you to cultivate and process, and then the dispensing and delivery are separate licenses. They could couple up dispensing with delivery. They could couple up processing with delivery. So there's lots of different variations that the legislator could move forward with. After they finalize that statute, the Department of Health will have to pass rules. During this rulemaking process, there might be rule challenges. So in my opinion, there probably will be rule challenges. So that will further delay this whole process when we have these challenges. Once those challenges are overcome and they pass these rules, now you're going to see the applications opening up. You're going to see a competitive application process. People will submit their applications. They will be scored. Winners will be announced. And once again, we may see lawsuits flood in for the people that do not win those licenses. So there's a lot of things that could potentially happen. There's just, if this was like a decision tree, there'd be, it'd be a huge tree that we'd be looking at. But in the situation where where the court rules in favor of Florigrown, my best prediction is that we're not going to see operational licenses until late 2022 or early 2023. I know that seems like a long time, but unfortunately, that's just how the process works. Now, the last thing I want to talk about is what would happen with the current 22 licensees if the court rules in favor of Florigrown on all these issues. You know, these 22 licensees, you know, some of them were issued under the previous statute, like Tara mentioned, but most of them were issued under this current statute 381.986. And in fact, even the ones that were issued under the previous statute, the first subsection of subsection 8 in 381.986 actually reissues those licenses to those people. So to the extent that this statute is found to be unconstitutional, people are questioning what will happen to the licenses that were issued under this unconstitutional statute. In my opinion, all 22 of these licensees have a vested property right. They've relied on the government and they've taken steps to move forward with their business. So I don't think that there's a situation where the court can strip these 22 licensees of their licenses. But it is important to note that in the last oral hearing, one of the judges did question whether the court had any authority to settle that one-pointer case. So that kind of opened a lot of people's eyes when that justice questioned, and this was really in the context of whether it's a special law or general law, that justice questioned whether the DOH ever even had authority to do something like that. And obviously the next question is okay, if that justice feels that way, and let's say the other justices feel that way, what would happen with those licenses that were issued under that settlement? Just as a way of background, 8 of the licenses were settled because they were 1 point away from a winning application. So that's kind of what he was referring to when the justice asked that question. But I think it's very, I just want to reiterate, I think it's very highly unlikely that these 22 licenses will be impacted by this court decision. But the other question that I'm asking, that I'm curious to see how this plays out, is that if we do go to a horizontal structure, well, right now these 22 licensees, not only are they vertically integrated, but they also don't have any caps whatsoever as far as how many facilities they can open up. So to the extent that we create this horizontal structure where someone could apply for one dispensary location or one cultivation location or one processing location, what then happens with the unlimited locations that these 22 licensees are able to expand into? I'll tell you that a lot of the license transactions and people acquiring these licenses right now are acquiring them on the assumption that there's really no cap on this expansion of the license. But it'll be very interesting. We'd kind of be operating under these 2 separate kind of frameworks where one set of licenses, these 22 licenses, really have no cap and really nothing controlling them, whereas now these new horizontal licenses are, you know, limited in scope and what they can do. So it'll be very interesting to see how that will play out. I'm not going to pretend to know how that will play out, but there are tons of possibilities. I kind of ran through just some of the implications, but there are certainly a lot of different directions the court could go on this, and I just wanted to leave enough time for everyone to ask some questions, and hopefully we'll be able to kind of dig in a little bit deeper and answer your questions. So that's all I got for now.
Thanks, Dustin. Tara and Dan, could you give us your thoughts on the outcome of the case? And Tara, we'll start with you.
We can't hear you, Tara. Or at least I can't hear you.
Am I just talking to myself over here on mute? Now can you hear me?
You were definitely talking to yourself on mute.
Perfect. Yeah, that's just my day-to-day existence, by the way. But what I was saying was I appreciate the overview that you gave, Dustin, and I think it's a good recap of some of the different possibilities. It's difficult to try to predict what the Supreme Court's going to do. I think from a pure textualist perspective, you can see them defaulting to, well, it says or in the constitutional language, and then it says and and requires vertical integration under what we have in 381986. My problem with what is in the constitutional language, or the amendment defines an MMTC, it gives a couple different categories. So, I mean, if you literally read that language, a medical marijuana treatment center could be an entity that possesses educational materials and distributes those to qualifying patients. I mean, or you can have a license just to transfer or administer related supplies. So if you look at there's two ors in the language of that amendment, what the definition of an MMTC is. So from a practical perspective, it doesn't make any sense. It was never the intention that we were going to have licensed MMTCs who were just dispensing educational materials and non-marijuana products to, you know, patients at home or through brick and mortar retail dispensing facilities. But then again, that's the way you can literally read that language, is that it would allow for multiple licensing options. And listen, a lot of other states have horizontal integration and allow for a breakdown of licensure according to, you know, sort of similar to what we had contemplated. But I just don't see that as being, from an ideological perspective, what the Supreme Court would want to support is having this wildly free market system that's going to have thousands of licenses issued. And I saw somebody make the comment, make Florida Oklahoma again, which is really funny because I feel like Oklahoma has given out enough licenses that it's like one license for every 3 residents in the entire state. I think they have the highest number of licenses that have been given anywhere. I mean, it's a significant number of licenses. I mean, I'm exaggerating, but it's a significant number of licenses that have been given out in other states. And I just don't see Florida going down that path of really letting anybody get a license here in the state to be an MMTC. And then, you know, the other interesting part is, Dustin, you said that we have 11 licenses that are up for grabs, right? The Department of Health said, hey, listen, first, this is not a special law. And second, there's still 11 more licenses that we can give out. For anybody who hasn't done the math or looked back at statutes, 5 licenses were given under a competitive application process, which along the way through other litigation was called a dumpster fire by one judge. They said it was the worst competitive application process, that it made no sense how it was scored. They brought in statisticians and mathematicians and nobody could figure it out. And now the Department of Health at one point during this case said that we would need 1,993 MMTCs to be able to have enough product for 453,000 patients. I cannot fathom that being the case. I mean, yes, I think a lot of MMTCs have run out of smokable flower product, but no, I don't think that there is an inability for a patient to obtain product in the state of Florida in 48 hours if they were to try. So it'll be interesting for the Supreme Court to have to reconcile what might be a position, you know, just generally on what they feel about the cannabis industry in Florida, and then what their judicial philosophy is. Because I believe by and large, judicial philosophy is that we should not be legislating from the bench, and we should be interpreting the words as they are written. And so that's going to create quite the ideological conundrum for those folks. And I don't envy the position that they're in, but I also agree that if it is deemed unconstitutional, I agree with Dustin. I don't think that these applicants, the prior approved applications and those existing licenses are going to go anywhere. It would be madness in terms of litigation if the Department of Health or the state were going to try to take away either folks who have bought licenses for 20, 30, 40, 50 plus $1 million and have now operated with, you know, dozens of locations statewide where they're retailing already. So I don't think that anything's going to happen to the existing 22. But I do think there is a huge question mark on how this could blow the doors open on it being a truly free market system here in Florida. Dan, I'd be interested to hear your thoughts.
So I'll give you sort of the Tallahassee perspective, right? So we, in our firm as lawyer lobbyists, interact with the legislature and the legislators individually all the time. And what we have in the state of Florida, just generally, not in cannabis, is we have a very purple, probably 51-49 electorate, maybe 50.5, 49.5 electorate, but we have a very conservative legislature. Our blue voters haven't been voting in House races well enough, and so we have a very, very, very red Florida House. And the Florida House has intervened in this litigation and have taken a very, very conservative approach to things, as you would expect. And so I could say you can't say anything definitively in the law, right? But I could say almost definitively that there's no way on earth that the Florida House and its membership is going to allow a wild, wild west scenario to open the doors for thousands of new dispensaries with folks who have not really gone through a licensure process at all. That would be so foreign in our legislature that you might as well be, change the state language to Mandarin, right? So with that, there's more palace intrigue to this. So that's just my take on this. I think the court finds a way to moderately hold up this statute. I think the way they're going to do it, in my opinion, is find that the or language was intended to be definitional in nature only. For example, there's things in there of the 15 or so things I listed off and read earlier that active MMTCs in Florida don't do today necessarily. You're not required technically to do all of those things. Educational materials, for example. No one goes into the MMTC and is like, hey, could you read me through the statute today? What is it saying, right? You go in there to buy product and you leave. There may not be a whole host of things that aren't happening. And I think it's a way for this court, which is hyper politicized, to do its conservative dealings and put the statute back in place to continue to move forward without blowing up. Here's an example of why I think that's going to happen. I don't know if anyone was following it about a month ago. It was a big talking issue in Tallahassee. It didn't really make statewide or national news on a huge level, but the governor selected 2 new members for the Supreme Court, one of whom was immediately seated, one of whom there was a debate over whether or not she had been a member of the bar long enough to qualify to sit on the bench as a justice on the Florida Supreme Court. And in a challenge by a Democratic senator from Orlando filed against the governor, our Supreme Court overruled the governor, saying, no, the person you've nominated hasn't been a member of the bar long enough to even seat herself. It was a very embarrassing ruling that I think had ripple effects throughout state government at the executive level and also on the judicial side, because the governor was forced by the Florida Supreme Court to appoint someone else. They said, literally, go back to the list, name someone else. All the others qualify, your choice. And they gave him a timeline. They said, it's got to be Friday at noon. And he didn't do it at noon. Then he said, well, it's got to be Friday at 5. And he did it about 5:05. So in the first oral argument of Florigrown, you had 7 justices. The bench wasn't full. You'd had retirements. On the second oral argument that happened a few days ago, the 2 new members of the Supreme Court are on the court. And, they don't maybe see it the way the same as the other 7 did. They've been on the court for about 10 minutes. And I think as those folks, having just gone through the judicial nominating process that Tara and I both work on, are going to be a little more loyal to the governor than maybe some of the others have been. They're new to the bench. They still see the governor as the appointer who he was just a few days ago. Final thing on this topic, and I'll get it back to the rest of the group. Maybe we open up some questions. It's very rare that the governor's legal office, its internal legal offices, argues a case. Generally, it's the department's general counsel or outside counsel. I've argued some of those cases for state agencies before. This oral argument, both the first at the Supreme Court and the second oral argument at the Supreme Court, were taken on by the governor's general counsel himself, the governor's #1 lawyer internally. His name is Joe Jaco. The day after the oral argument, Mr. Jaco submitted his resignation. Now, I don't think it ties to Florigrown at all. There obviously was either some personal reasons or professional reasons not tied to Florigrown. But I just found it very interesting that the governor and the governor's general counsel saw this case as such critical importance that they put their #1 lawyer on the case. And then the next day, he's tendered his resignation. And today, because my firm is in the case, we got notice that he's removed himself from the process entirely. Just great palace intrigue there. You could talk about that for an hour and why that all happened. But anyway, I'll get back to you guys.
Yeah, so
I'm interested.
I know people get very frustrated when lawyers kind of don't give an opinion on where they think things are going. So I'm going to give an opinion. Obviously we talked about the possibilities and no one really knows, but I know Dan and we kind of agreed to disagree prior to this presentation, but I'm going to go ahead and agree with Dan. I think the Supreme Court's going to find a way to say that this statute is constitutional, that it's not unconstitutional. And I think, when I first heard about this case and I just kind of briefly read the argument and saw the or and the and argument, I said, oh, this is an easy case. You look at or in the Constitution, you look at and in the statute, those contradict one another. But I think Dan makes a very important point that once you look at the actual constitutional amendment and you see that it's just a definitional term. So they're just defining what an MMTC is. An MMTC is one that does any of these things, one or all of these things. There's an or there. It's just defining what an MMTC is going to do. And then in Section E of the Florida Constitution, it explicitly states that nothing in this changes the fact that the legislator could draft, legislation that is consistent with this constitutional amendment. So, the legislator's power is broad in drafting policy. It just simply can't contradict what the Constitution says. So I think in this situation, when you look at the actual structure of the constitutional amendment, I do not think the intent of the drafters was to say that that the legislator can't create a fully vertically integrated structure. I think the legislator really had policy discretion to decide whether they wanted a horizontal structure or a vertical structure. So that's my best guess on where the court will come up. But I give the caveat, this is not legal advice, and do not rely on anything that I'm saying right now, because we really don't know where we'll end up.
Yeah, I think y'all are right. I think that they're going to try to come up with a way to keep vertical integration and not have to go to a horizontally integrated market. I mean, it's most of the licenses, and I think, Dan, maybe you mentioned this in the beginning, was does Florigrown just want a license? Because 17 companies got their licenses from suing the Department of Health, right? I mean, one of the latest rounds that were issued was 2 years ago in the Spring Oaks case. I mean, again, 8 licenses all came from litigation. If you even look at Florida statutes, there is a specific provision in there that says that the department shall license any applicant which is in a judicial challenge pending as of January 1, 2017, or was ranked within 1 point of the winner, et cetera, of the region that they were in. So we even put into statutes, we got to give out some licenses if you're in litigation. So will Florigrown maybe get a license from this? Wouldn't surprise me. Is the entire system going to be dismantled? That would absolutely shock me. And I don't think we've talked about what the outcome would be if, for example, the state said, okay, fine, those licenses were issued in error, but we're going to allow MMTCs to continue, the ones currently licensed as of today, to continue with their vertically integrated operations or become horizontally integrated if they so choose. I don't know what you two think that would look like, but it would be very interesting to see if, given the option, which of the licensed companies today in Florida would not want to take on all of the roles that they currently have and may just want to be retail distribution centers, or maybe just want to be cultivators. I would think they would all more predominantly want to be just in retail dispensing. I mean, if you look, a lot of brands that have come in from other states came in as retail brands. They were never in the business of cultivating or producing their own products. So it was very foreign to some of those licensees that bought licenses in the recent years. But I don't know, Dan or Dustin, if you have a quick thought on that before we open it to Q&A.
You want to go first, Dan?
Yeah, I would just add, and again, this is not my personal take. I'm a left-leaning moderate, but having to deal with this legislature on a daily basis, I just can't get past how conservative our leadership is. And that for that reason, one, the powerful lobbyists of the group of MMTCs that a lot of folks, not me, call the cartel, right? They have the most powerful lobbyists in the state, maybe in the country. They have the biggest, baddest guys on their side, and gals, obviously. they are not going to allow, in my opinion, anything that would hurt their bottom line. Trulieve, which is dominating the market, wants to continue dominating the market. And I don't think their CEO, who doesn't live far from me and is a very successful operator, wants to open the door to all of these competitors that could potentially upend their success in this state. And so for that reason, I would say, no matter what happens, even if something very, very strange that Tara said, the mind-blowing scenario from the Supreme Court, if that happens, there will be either a special session or during the general legislative session that begins in March to put it back together in a way that the Trulieves and Curaleaves and Surteras of the world can continue their very successful business models, while there might be a moderate interruption from people having the ability to have retail. I mean, it's silly that if I'm walking into a store, I can't look at a Surtera product and a Trulieve product in the same store. It's silly, but it's the law today. I think there might be some tweaks to that from the legislature in coming sessions, but the idea that we're going to go Oklahoma, Colorado, Illinois, not in my opinion.
So I think Tara brings up a really interesting question, just not from a legal perspective, but from a business perspective. And I get a lot of calls from different entrepreneurs that want to get in the hemp or marijuana space, and you'd be surprised how many want to become a vertically integrated CBD company. And I generally caution people that obviously in the marijuana world here in Florida, you have no choice. You have to be vertically integrated. But from a strictly business perspective, most of the innovation that comes about in any industry is from smaller businesses that are experts in one particular area. So it's, the old saying, you could be a jack of all trades or a master of and a master of none. If we truly want to innovate and create new products and new processes and intellectual property, I think breaking it up will breed more innovation, and certain companies that are expert at dispensing and they feel very strongly about their dispensing footprint, they may say, okay, if I could spin off cultivation and sell it off for 40, 50, 60 million dollars, I don't know, you pick your number. If I could go and spin it off and really focus on packaging and dispensing, and then buy my product and squeeze those cultivators, because look, in every industry, the person at the bottom of the supply chain generally gets squeezed. I came from the roofing industry, one of the oldest industries, and I was running a multi-state manufacturing company, and the lower down in the supply chain you go, the more that person gets squeezed. So or someone might say, we're the best cultivators, and that's what we want to focus on. We don't want to worry about opening up 50 dispensary stores. We want to focus on creating unique genetics and creating unique strains and unique methodologies for growing and processing. So we want to spin off and sell our dispensing footprint for, X million dollars. So I actually think the vertical integration was something that made sense in the beginning, because the DOH really wanted to control it, and they didn't have the resources for all these licenses doing all these different things. But I think as the industry progresses, if we really want to see innovation, I think it's important that we eventually start going towards a horizontal structure. And I think some of these vertically integrated companies may, from a business perspective, make the business decision that they'd be willing to spin off a certain part of their supply chain. That's all I got.
I'm gonna read off the first question that I have, and then I'm gonna turn it over to the panel. So the question is, one thing I noticed in the last oral argument session was a great deal of attention dedicated towards deciphering whether the class of licenses was open or closed. Based upon the questions being lobbed from the bench, it seems as though they're strongly considering that the class is an open class. Are there any potential ripple effects, either in the cannabis industry or elsewhere, if the court considers the class to be an open class? Would this potentially affect the language of upcoming recreational marijuana initiatives?
So if it's all right with everybody, I'll take this. So I've had the opportunity, I've litigated a couple of these closed class cases. It's open versus closed in this particular instance refers to, there's requirements to pass what are referred to as special acts. So general laws have statewide implications. They're not directed at a certain group of people or companies, and can be passed as general laws, like 99.9% of laws are passed. If a law is passed that is strictly to a closed class of companies or individuals, it needs to be passed as a special act. And there's constitutional provisions that tell the legislature, here's how you pass a special act. 381-986 was passed as a general law. So start with that baseline. So the argument that Florigrown is making is that this should have been passed as a special act because there's a closed class of companies who were awarded licenses via certain provisions of 381-986. And so I'll take off my lawyer lobbyist for clients hat, and just as a person who's reading the case, it's hard to say when the statute says if you were litigating with the Department of Health over a license on date certain that's already passed, that's not a closed class. I'll open that to the group if anybody on the panel wants to, just for the sake of sport, disagree with that. Joe Jacobs certainly did in his argument, but that to me is difficult to overcome.
And I'll agree with you on that aspect of it. It didn't seem like, at least from the questions during oral arguments, that the justices were buying into Florigrown's arguments. At least the way they worded their questions seemed like they were agreeing with Joe on what he was saying, because he was arguing, hey, listen, the fact that you can sell these things on the open market means it is not, in fact, a closed class. There's these other ways that you can get licenses. And don't forget about the 11 that are still out there. But for anybody who's holding their breath on new licenses coming out, also don't forget that there was a deadline in statutes of, October 2017, that certain licenses were supposed to be issued, and we're still waiting for that. So, there's been a lot of problems with license issuance and the department meeting some of those statutorily mandated deadlines for license issuance. But at the end of the day, it didn't sound to me like the justices were buying Florigrown's arguments on it being a special law.
And getting back to the second part of the question, Tara, there was it rolled into sort of like what does this do about the rec market? To me, it doesn't have any implications. What closed or open class has no implication whatsoever on a rec market. If we're going to get a rec market, somebody's going to spend a ton of money on a constitutional amendment and run it on a presidential election year, I guess in 24 at this point, because 20 didn't make the ballot. There's no way that happens in the legislature, and there's absolutely no way that happens via the courts.
I agree with you on that. It's going to take a presidential election year, I'm sure, to get that passed. I don't think this has anything to do with rec. To me, the only impact on rec is that people will say, you know what, I'm sick of having to wait for the Department of Health to comply with statutes. I'm sick of all of these lawsuits that are going around. Why don't we just allow for recreational and open up the market and just make access much easier on that front? If they can't get it right on implementing medical, then let's just have recreational. But I don't know if the average voter is going to be doing that thought process in their head, but I think at the end of the day, no substantive impact on whether this is going to usher in recreational. And you're right, legislature is not going to pass any laws. Even if passing those laws would mean they could have better control over recreational than what they may get from a ballot initiative. Because remember, by the time it gets on the ballot, at that point, the legislature's role is just going to be to implement whatever the voters may pass. So I think they could have much greater control. And if, the conservative majority would want that, then they really should pass an adult use bill that makes it very highly regulated. Otherwise, we'll have to wait and see what constitutional ballot initiative gets enough signatures and is able to have enough money to support it to get on the next ballot.
Yeah, I'll just to kind of summarize. Yeah, I mean, the question of whether it's open and closed really just goes to the constitutionality of the statute. So it did seem to me like the Supreme Court justices were leaning towards it being open, which means it's a general law and not unconstitutional. So that's kind of, I think, summarizing what we're saying right now.
Thanks, everyone. We have about 8 more minutes. I'm going to read the second question. Speaking to the potential gap in operational licenses being granted that was mentioned by Dustin earlier, what do you all see happening with the industry in that time, and how do you see this litigation and potential expansion of the industry affecting the state's cannabis legal field?
So you know, there's so many different possibilities on what's going to happen with the market. So, but one thing I'll address kind of the last question in there. What does it mean for the legal field? Look, I think right now there's 22. If you want to practice marijuana law strictly in Florida, there's 22 companies you could go talk to. 22. That's your total available market, right? When you're doing a business plan, you talk about what's your total available market. There's 22. If we start opening up our, you know, this licensing to being horizontal, and we allow more licenses in, and we start looking more like, you know, Colorado or Oklahoma or any of these other states, California, your total available market as an attorney obviously expands tremendously. So now, rather than going after 22 licensees, you know, maybe there's hundreds of licensees for you to potentially have as clients. So there's plenty of room for Tara to have her clients, and Dan to have your clients, and me to have my clients, and for us to all collaborate with shared clients, you know, and that's kind of what's going on right now, even with these 22 licenses. But certainly a further expansion of the market, I think, would be very good for the legal market, I guess, as far as having more potential clients out there.
And I will say one of the reasons that I thought it was really important to teach a class on this is because of the intersectionality between cannabis and so many different practice areas. So even if you're in Florida right now and you don't have one of the 22 licensed companies as one of your clients, there's still a significant amount of work that you could have, right? You could be representing landlords who are working to lease or sell property. You could represent physicians. You could represent lenders. I mean, I write policies for banks on marijuana-related banking policies and hemp policies, right? I mean, there's a big aspect of additional clients that you can represent. I think the high dollar clients are obviously the licensed companies themselves, but it is not as if, you know, even if you just have one of those companies as a client, that you're necessarily doing all of their work, because some of it is very specialized, right? When you might be representing a cannabis company on their real estate work, but that doesn't mean that you're necessarily handling some of the specialized litigation that they may be part of, because don't forget, the Plaintiffs Bar Association loves the cannabis industry because they love suing them, right? They see them as having very deep pockets. They also see that for the hemp industry, that or there's just a lack of case law and precedent for them to go after. So it's good opportunity for them to be the lawyer who gets to establish some of that. So that's why you see these waves of class action lawsuits in both sides of the industry. So there's certainly a lot of work that can be done outside of just, you know, doing the regulatory work for those companies that are already licensed in the state. And I'm sure, you know, Dan, you would agree with the same. I mean, your law firm as well represents a number of different issues. And so I think for anybody who wants to get in this industry, or even if you don't, you really should know about it, because it's not going to go away. To me, it's you know, it's like if you're going to represent the hospitality industry, you better know something about liquor licensing, right? Or if you're going to be in the real estate or zoning industry, you better know something about liquor licensing and medical marijuana licensing, because that will be impactful to your clients as well.
I think we've only got a couple minutes. Let's get one more question so I don't have to disagree with those guys, because I think they answered the question just like I would. I agree with everything they said.
The next question is super quick. When will the next license round happen? And speculation is fine.
What I tell my clients is my son, who is 5, will probably be a lawyer for one of the companies who gets one of those.
Yeah, we don't know. We don't know. I think we all agree that we don't expect for any license to become operational anytime prior to probably the end of 2021 under any situation. Now, licenses might be awarded, then there might be lawsuits, but I think we all agree that we're probably at least a year away before any license becomes operational. But after that, like, you know, you see what this Florigrown case has done. It's literally put an injunction for the past several years on the entire industry, and that's all it takes is one lawsuit to really delay everything. So unfortunately, I get that question a lot. I know Tara and Daniel do too. We get calls on when is it going to be open? How much of a head start would I have if I bought a current license? And, you know, it's you can only guess it right now because we don't know what's going to happen.
Yeah, I agree with that. I mean, look at how quickly the hemp industry was able to go from, you know, enacted legislation to license issuance to cultivation, plants being put in the ground. very quickly, and that's because there was no litigation against the state. But the industry in Florida has really been stymied because of litigation. So I think the only thing that we can all say with certainty as lawyers on this call is there will be litigation, right? One way or another, I think we can all say there's going to be additional lawsuits that are going to come out of this decision.
That is, if I'm in, let's say I'm not doing regulatory work for an MMTC currently, but I'm representing a hedge fund that has access to $500 million. Are you advising that client to get into this industry and battle against Trulieve when they've had 5 years to open competitive operations and expand their business and have a following? I don't know if I'm that hedge fund manager that I'm looking at Florida and saying, you know, I really want to be licensee number 23 down there to take on that 500-pound gorilla of Trulieve and Company. I've had some folks who have gotten close to a deal and then gotten cold feet when they see what the industry looks like from the numbers Tara mentioned at the very beginning of this call. There's so much being sold already. There's so many stores already that as much as people think, I want to get in the cannabis industry, being an operator is hard, particularly when vertical integration is the requirement. This is not an inexpensive industry to get into.
Dan, I'm gonna disagree with you on that one. I'm excited. So I mean, look, not that I totally disagree with you. I mean, you really got a hedge fund with $500 million really has to look very closely on it. But if I have $500 million to deploy, I don't even think I need 500 million. Let's say I had $100 million to deploy into this market. If you have to acquire a license for $25, $30 million with 400,000 patients currently growing at 2,000 patients per week, with a population of 20 million in Florida and a tourist of 150 million, really what you're buying is the opportunity to build out an uncapped infrastructure set up to capitalize on what will be in the future the largest cannabis industry, which will be Florida. So, I mean, I think that 25 million, 30 million, whatever the licenses are going for right now, at the end of the day, it's what's not so important about the price you get in, whether you pay 20 or 30 million, because the goal needs to be is to build a multi-billion-dollar company. And if you have the capital to deploy to capitalize on this asset that is uncapped, I think you could do very well. Now, if you don't have that capital, if all you have is, $50 million, so you could buy the license for 25 and then maybe build out for 25, it may not be worth 25 to you. But if you have the capital to fully utilize this asset, and this license is the asset, if you could fully utilize that asset, I think that you could very, very, very much so, if you can execute well, build a multi-billion-dollar company. And there's not many opportunities out there where you could buy a $25 million asset, deploy another 50 million, and build a billion-dollar company. So I think that's kind of the flip.
Yeah. And I mean, I know we're at time, so I'll say that I do agree with some of the sentiments that both of you have expressed. I do think there's a lot of room in the market for other operators to come in. I don't think that Trulieve is necessarily going to be the front runner forever, right? Especially when that patient count starts to continue to increase. And if we go with recreational, and if our adult use program has reciprocity, so that if you come into this state as one of those between 118 and 150 million tourists a year that come in, and you can get your recommendation filled in Florida from a doctor from out of state, I mean, it would be a profoundly impactful change to the current dynamics of the medical cannabis market in Florida. So I think it's foolish to believe that every cannabis company in here is not banking on and anxiously awaiting for recreational, because that is exactly what they should be banking on and anxiously awaiting for, and hope that if there is a constitutional ballot initiative in 2024 or 2022, that it says very specifically that the existing licensed companies would be able to be the ones who also sell for recreational, right? Which is what was almost on the ballot for this election. So it'll be interesting to see how it plays out in terms of who can be selling on a rec market, and whether it's going to be just licensed MMTCs, or if we're going to open up a whole new licensure process for companies to be solely rec and not medical, who knows? But I think recreational sales are really what's going to set Florida apart from the rest of the country when they do come.
It's after 1 o'clock. Thank you, everyone. Tara, Dan, Dustin. I will send the recording out to you guys if you guys want to use it, and then I will be posting it on our group's Facebook page. Sorry for anyone whose question I did not get to. We were kind of in a time crunch. But thanks again. and we will see you soon.
Thanks so much.
Thank you very much. Have a good one, everyone.